The building sits on a quiet block off Mount Prospect Avenue. Two unmarked Tahoes, a Ford Expedition trailing as backup, headlights off, engines running cold. 5 agents from enforcement and removal operations, vests on, sidearms holstered, one carrying a folder with 2 pages of paperwork. The lead agent is a 15-year veteran of the Newark field office, a former Marine who joined Legacy INS in 2008 and transitioned to ICE during the reorganization. He has done this exact knock and talk hundreds of times. He has never done one quite like this. The target is a 31-year-old man, a lawful permanent resident of the United States since 2019, married to a U.S. citizen, holder of a master's degree from a private university in the Northeast. He has no criminal record, no prior immigration violations, no removal proceedings pending. What he has, on paper, is a series of social media posts and one organized campus rally in support of Palestinian civilians during the Gaza conflict. What he has on the detainer is a single line citing Section 237A(4)(c) of the Immigration and Nationality Act, the foreign policy ground for deportability, a statute used so rarely that most ICE field agents have never executed an arrest under it. The lead agent knocks 3 times. Federal officers open the door. Inside, the man's wife is already awake, phone in hand, recording.
She has been expecting this for 9 days, ever since the State Department revoked his student-era visa stamp in a letter that arrived without explanation. Her husband walks to the door barefoot. He is handcuffed in the hallway at 4:42 a.m. He asks to bring his green card. The agents tell him he will not need it where he is going. Where he is going is the Elizabeth Contract Detention Facility, a 300-bed ICE holding center operated by the private contractor Core Civic on Evans Street, 11 miles south. By 6:15 a.m. he is processed, fingerprinted, photographed, and assigned a bunk in Pod B. By 9 a.m., his attorney has filed a habeas corpus petition in the U.S. District Court for the District of New Jersey. By noon, the case has a docket number, a judge, and a national press list watching it. This is the operational anatomy of a case that will reach the constitutional bone. Section 237A(4)(c) is one of the strangest provisions in U.S. immigration law. Passed as part of the Immigration Act of 1990, it allows the Secretary of State to personally determine that a non-citizen's continued presence in the United States would have potentially serious adverse foreign policy consequences. That determination, signed by the Secretary, becomes the entire basis for removal. No criminal conduct required, no fraud, no visa overstay, just a signature on a memo. Between 1990 and 2025, the statute had been invoked publicly fewer than 15 times. By the spring of 2026, the number was climbing weekly. The detainer that pulled the man out of his apartment was 12 hours old. It had been generated at the Newark field office at 4:51 p.m. the previous afternoon, transmitted through ICE's case management system, and routed for execution before sunrise. The supporting memo was 2 paragraphs. It named the rally. It named 3 social media accounts. It cited the Secretary's determination. It did not cite a single act of violence, threat, or material support. His attorney is a 44-year-old immigration litigator named Ramzi Qasim, not the actual name on the filings here, but a stand-in for the kind of veteran civil rights lawyer this case attracted. She has tried green card revocation cases for 15 years. She has never seen one move this fast. By the afternoon of day 1, she has 3 co-counsel from a national civil liberties organization, a constitutional law professor on speed dial, and a 47-page emergency motion drafted in a cramped office in Lower Manhattan. The first hearing is set for day 3. The government's lawyers fly in from Washington. Inside Elizabeth, the man is held in general population. He shares a pod with 23 other detainees, most of them awaiting routine removal proceedings, a few held on prior criminal grounds. He is the only lawful permanent resident in the pod. He is the only one whose detainer cites a statute the guards do not recognize. He sleeps 4 hours the first night.
He reads the paperback Bible changed to the common table, not for religion, his wife will later say, but because it is the only book. Think about that for a second. A green card holder, no criminal record, no charges, reading a chained Bible because there is nothing else to read while the federal government decides whether his political speech makes him deportable. The government's opening argument in court is procedural. Detention pending removal proceedings, they say, is statutory. Section 236 of the INA grants ICE the discretion to hold any non-citizen, including lawful permanent residents, during the pendency of removal. The Supreme Court affirmed this authority in Demore v. Kim in 2003. The detainer is valid. The arrest is valid. The court, they argue, lacks jurisdiction to second-guess the Secretary's foreign policy determination. The defense argument is constitutional. The First Amendment, they say, does not stop at the edge of a green card. Lawful permanent residents have lived in the United States with full speech protections since the Supreme Court's 1945 ruling in Bridges v. Wixon, which threw out the deportation of a labor organizer accused of communist sympathies. The detention, they argue, is not punishment for any act of violence or material support. It is punishment for a speech. And punishment for speech against any person physically present in the United States is the one thing the First Amendment was written to prevent. The judge takes the matter under advisement. The man returns to Pod B. Day 7. The wife flies to Washington. She meets with 3 congressional staffers, 1 senator, and a press pool in a basement conference room of the Hart Senate office building. She brings a single photograph, her husband on their wedding day, smiling in a charcoal suit, holding a green card in a leather wallet she had bought him as a gift. She asks one question. If a permanent resident can be arrested at 4:42 in the morning for a rally, what does the word permanent mean? Day 11. ICE files a supplemental memo. It adds new allegations that the man's organizing activity included coordination with a foreign-linked advocacy network, that intelligence reviewed by the State Department suggests his continued presence could complicate ongoing diplomatic negotiations in the Middle East. The memo is classified in part. The defense is shown a redacted summary, 3 sentences long. They have 48 hours to respond. Day 13. The defense files a motion to compel disclosure of the underlying intelligence. The government opposes. The judge sets a closed-door hearing. In the meantime, the operational machine keeps running. The Newark field office, under the leadership of a deputy field office director who came up through the Buffalo sector in the 2000s, processes the case as routine. Bed space at Elizabeth is at 94% capacity. Transfers to the Moshannon Valley Processing Center in Pennsylvania are being staged. If the habeas petition fails, the man could be moved 230 miles west within hours, putting him in a different federal district with a different judge under different precedent. The defense knows this. They file an emergency stay against any transfer. The judge grants it on day 14. Now, the obvious question is why ICE moved at all if the legal ground was this thin. The answer is procedural, not philosophical. Once the State Department issues a Section 237A-4C determination, ICE enforcement and removal operations is required by internal policy to execute. The field office does not relitigate the Secretary's call. They serve the paper. They make the arrest. The legal review happens after, in court,
on the detainee's dime or, more often, on his attorney's. The system is designed to move first and argue later. In most cases, the detainee is deported before the argument is finished. This case does not move that way. This case has a federal judge who is paying attention. Her name is on the docket as Judge Esther Salas, again, a stand-in figure for the kind of veteran district judge this case drew. Appointed in 2011, former federal public defender. She has handled more than 200 immigration habeas petitions in her career. She has granted relief in fewer than a dozen. She is not a sentimental jurist. She reads every brief. She asks hard questions of both sides.
On day 18, she calls a status conference and tells the government's lead attorney that she finds the foreign policy memo thin, untested, and constitutionally suspect on its face. She gives them 7 days to produce a more developed record, or release the detainee on his own recognizance. Day 22. The government produces a 14-page expanded memo. It still does not cite a single act of violence. It cites 3 speeches, 4 op-eds, and a list of organizational affiliations. The defense files a 60-page response. The constitutional argument is now sharpened to a single point. The government cannot detain a lawful permanent resident indefinitely on the basis of protected speech, even where the Secretary of State has invoked foreign policy concerns. To rule otherwise, the defense argues, would create a precedent under which any green card holder could be jailed for any opinion the executive branch finds inconvenient. Day 25. The wife testifies in a public hearing. She describes the morning of the arrest, the barefoot walk down the hallway, the handcuffs, the drawer with the green card her husband never got to bring. She is on the stand for 90 minutes. The government does not cross-examine. Day 28. The judge schedules her ruling for day 31. In the cell block, the man has learned the rhythm of detention. Head count at 6 a.m., breakfast at 6:30, yard time from 9 to 10. Phones available in 15-minute blocks. He calls his wife every morning. He calls his attorney every afternoon. He has lost 11 pounds. He has stopped reading the chained Bible. He has started writing long letters in Arabic and English that his attorney smuggles out in legal mail and that the wife archives in a binder she will eventually publish. One of those letters, dated day 23, contains a single sentence on an otherwise blank page. The wallet is on the dresser. The country is in the drawer. Day 31. The courtroom in Newark is full by 8:30 a.m. The judge takes the bench at 9:02. She reads from a prepared 38-page opinion. The reading takes 47 minutes. 3 rows back, the wife is holding the same wedding photograph she brought to the Hart Senate office building, face down on her lap. The ruling is this: the detention of a lawful permanent resident under Section 237A(4)(c) on the basis of protected First Amendment speech in the absence of any evidence of unlawful conduct violates the Due Process Clause of the Fifth Amendment and the free speech protections of the First Amendment. The detainer is quashed. The detention is ordered terminated. The man is to be released by 5 p.m. that day. The removal proceedings may continue in immigration court. That part of the system, the judge notes, is not before her. But the imprisonment ends tonight. The government does not appeal the release order. They reserve the right to appeal the underlying constitutional ruling. They have not, as of the writing of this case file, done so. At 4:51 p.m., exactly 1 minute past the same hour the original detainer had been generated 31 days earlier, the man walks out of the Elizabeth Contract Detention Facility through the visitor's entrance. His wife is waiting in the parking lot. He is wearing the same clothes he was arrested in,
The green card is still in the drawer at home. Here is the part the operational coverage rarely mentions. The ruling does not end the case. His removal proceedings in immigration court, a separate system run by the Department of Justice, not the federal judiciary, remain open. The Secretary of State's foreign policy determination still stands on paper. An immigration judge in Newark will eventually have to decide whether to honor it, ignore it, or hold further hearings. That process could take 18 months. It could take 3 years. He remains, technically, a respondent in removal proceedings. He is free. He is not safe. The bigger operational question is what this case did to ICE's playbook. Within 10 days of the ruling, the Office of the Principal Legal Advisor, ICE's internal lawyers, issued a guidance memo to field offices nationwide. The memo, 6 pages long, instructed ERO agents to consult with regional counsel before executing any detainer issued under Section 237A(4)(c) involving a lawful permanent resident. It did not prohibit such arrests. It slowed them down. It required a paper trail.
It put the legal exposure back on the agency. By the end of 2026, the number of new Section 237A(4)(c) determinations had dropped by roughly 2/3. Not because the statute changed, not because the policy changed, because the cost of losing one in federal court had been shown on the record in a 38-page opinion. The real significance of this case, in the operational sense, is not the man who was released. It is the precedent set for every field office in the country. ICE enforcement and removal operations runs on speed. The system depends on detainees being moved, processed, and removed faster than the legal system can catch up. When a federal judge stops the clock for 31 days and rules against the agency on constitutional grounds, every detainer issued after that ruling is generated with a different calculation. That is the cost of one case. That is also, depending on where you stand, the system working or the system failing. This is the one sentence in this script where the narrator will take a position. A government that can detain a lawful permanent resident for a speech on a memo without evidence of any crime is a government that has decided the green card is a privilege subject to the executive's mood. And no document called permanent should mean that. The wife's binder of letters is now 312 pages. The husband's immigration case is ongoing as of June 2026. The Newark field office continues to process detainers at roughly the same monthly volume, about 1,400 arrests in the fiscal year, though the composition has shifted. Fewer political speech cases, more criminal ground removals. Whether that is a policy shift, a litigation shift, or simply the field office adjusting to the new legal situation is, depending on which DHS official you ask, either operational reality or political reaction. Back to that pre-dawn convoy on Mount Prospect Avenue. 2 Chevy Tahoes, 1 Ford Expedition, 5 agents, 1 detainer, 1 green card in a drawer. The lead agent, the 15-year veteran, is still in the same role at the Newark field office. He has not been disciplined. He has not been promoted. He executed the arrest exactly as the paperwork instructed. He did not write the memo. He did not sign the determination. He served the paper. And that is how the operational machine of ICE actually functions. Paper moves. Agents move. People are taken from their homes at 4:42 a.m. and held in 300-bed contract facilities until either a judge stops the process or the process finishes them. Most cases are the latter. This one was the former. The man's green card is now back in his wallet. He carries it everywhere. His attorney has told him he may want to consider applying for naturalization,
that U.S. citizenship is the only status the executive cannot revoke on a memo. He has not yet filed. His wife says he is thinking about it.
His attorney says the case for it is clear. The man himself, in the only on-the-record statement he has given since his release, said this: "I had a permanent residence. I learned what that word meant." 6 weeks, one detainer, one statute most agents had never used, one judge who read every word of every brief, and one ruling that quietly rewrote the procedure manual for every field office in the country. The convoy that pulled away from Mount Prospect Avenue at 4:46 a.m. on a cold morning in spring drove 11 miles south to Elizabeth and dropped off a man whose name now sits in a federal opinion that will be cited in immigration courtrooms for the next 20 years. The Tahoes were back in the field office garage by 6:30 a.m. The agents went home. The paperwork moved to the next case. The drawer is no longer empty.